The Madlanga Commission heard more testimony this week that cut straight to the heart of how power has been abused inside the criminal justice system. Retired police generals and a former prosecutor described repeated attempts by politicians and senior officials to block investigations or redirect them away from connected individuals. The evidence was not dramatic confessions but a steady record of instructions, ignored dockets and sudden transfers that left cases to die. What matters most is what this does to the rule of law. Section 179 of the Constitution gives the National Prosecuting Authority independence. The testimony suggests that independence was treated as optional. When a minister or party official can pick up the phone and have a case reassigned or starved of resources, the separation between political authority and prosecutorial decision-making collapses. That is not a technical breach. It is the practical end of equal application of the law. The Commission has now seen patterns that repeat across different administrations. Cases involving state contracts were slowed or dropped after interventions from above. Investigators who pushed forward found themselves moved to other units or placed under investigation themselves. One witness described how a docket on a senior ANC figure simply disappeared from the system for months. These are not isolated lapses. They show a system that could be switched off when it threatened the wrong people. The constitutional implication is straightforward. If the executive can control which crimes are pursued, the courts lose their ability to act as a check. Judges can only decide the cases that reach them. When dockets are buried before they arrive, judicial review becomes a formality. The Bill of Rights guarantees everyone the right to equal protection of the law. Testimony that senior figures enjoyed de facto immunity makes that guarantee look hollow. Defenders of the old order will argue that some interventions were legitimate attempts to correct overzealous investigators or protect sensitive operations. That defense needs to be tested against the record. The Commission is not being asked to accept every complaint at face value. It is being asked to establish whether there was a consistent practice of political direction that went beyond normal oversight. So far, the evidence points to direction that crossed into interference. The longer this continues without consequences, the more damage is done to public trust. Ordinary South Africans already doubt that the law applies evenly when they hear that certain names could not be touched. That doubt hardens into certainty. A constitutional democracy cannot survive if large parts of the population believe the rules are for some and not others. The Commission's job is not to restore trust with words. It is to lay out the facts so that institutions can be rebuilt with real independence. Reforms that follow will have to go beyond new policies. They will need structural changes. Fixed terms for the NDPP that cannot be shortened by political whim. Protected budgets for specialized units. And clear rules against any minister issuing instructions on individual cases. Without those, the same patterns will return under the next government. The testimony also raises questions about the judiciary's own role. Some matters that should have been challenged in court were allowed to stall. Judges have a duty to guard their own process. If they accepted unreasonable delays or weak explanations from the state, they contributed to the erosion of accountability. That part of the record deserves scrutiny too. South Africa's constitution was written to prevent exactly this kind of capture. It placed independent institutions between raw political power and the enforcement of law. The Madlanga Commission is showing how those protections were worked around in practice. The findings will not fix the damage on their own, but they can make it harder for the next administration to repeat the same tricks without being called out. That is the minimum the rule of law requires.